It won't go on your record as a permanent criminal conviction.
A show cause somewhat of a review. This is for a son of Mr. Schmitz, who is in 8th grade, Cameron, that had experienced in the past some difficulties. If the court would remember, he was.
Let me stop you, because this file looks like a file that's never even been seen. Last I've got, it was adjourned until August 12, and nothing's happened since then. So I don't have any plea. I don't have any sentencing. Does he got another file?
We have a trial at 11 o'clock. That's different. But this was basically a parental responsibility case, if I understand.
Yeah, but there's never been a plea taken.
This is the Van Buren page. Angela is our girl on this page.
Right.
Yeah, you need to speak to Angela. She's out there.
Yeah, I don't see there. I don't have a plea on this.
Okay.
Yeah.
So
That's it. Wrong process.
incident date is August 28, 23. Are you with him?
Hey, everybody. I'm not sure what happened there. Thank you for coming back. I guess we were doing a test run. Test run was successful, so let's go ahead and knock it out. We got quite a few different judges today. We got Thurston County. We just showed Judge Oakley. We got Judge Simpson. We got Judge Allen. We got Judge Clayton, and we've even got some Judge O'Donnell for Kathy. So we're gonna show some of that for Kathy. Thank you guys so much for coming out. We appreciate it. Saturday night. So this morning, Judge Boyd went live, and it was a really odd thing to see her go live on a Saturday. And then who do I see in the chat was Gina. So hey, Gina, I got to say hi to you right before Judge Boyd cut off the chat. So good morning. So hey, we got court vibes back. Thank you, Kathy. And so all right, we're gonna go to one night off and I fall apart. So let's go to Judge O'Donnell. Let's show a little bit of that. He's got a couple of good ones for tonight for us.
He's prepared this morning to waive his final hearing and enter a plea of guilty to the violations, Your Honor.
Is that what you want to do, Mr. Hobbs?
Yes, sir.
All right, what's your plea to those charges?
Yes.
Guilty?
Guilty, yes.
All right. All right, I'll accept your guilty plea and find you guilty. What do you want to tell me?
Well, first, I'd like to thank you for pointing out the mental health issues and having me go to signature. They came and reached out to me, and they got me signed up for when I get released out of here, so I'm still going to continue that issue right there. I want to say thanks to Dave. He was, you know what I'm saying, it's sorry to put him in this situation because he was helping me out as much as possible, you know what I'm saying, and I just want to be able to get back to my family. Luckily, my mother just got out the hospital last week, so that's a good thing. She's still dealing with her chemo, and you know, it's a process. I thought I was doing a little bit of progress, so I'm just going to try to stick with it and just move forward.
Well, when you say move forward, how are you going to move forward?
Well, right now, you know,
You're in for 2 more months, right, on the Cuyahoga case?
correct.
Okay.
You know, and even down there, I had some certificates. They didn't let me bring my paperwork with me, but even down there on my own, I did 12 steps, PTSD, mental health. I did some criminal law, business. I got certificates for all that. Like, I'm just trying to figure it out. Like, you know, trying to, you know, I got to get to the real world to really put the practice in. But I got to, you know what I'm saying, I got to figure this out. So, you know, with a little bit of cushion where I can still be able to, you know what I'm saying, make mistakes, because I'm not perfect. I'm going to make mistakes. There's going to be some things I'm going to do wrong. It's going to be some things I'm going to do right. And I got to put all that together and come out with a better me. So steps and there's just levels to it that I'm going to take myself through so I can be able to get out there and, you know, never see no courtrooms or, you know what I'm saying, and deal with my mental health and things like that, because a lot of people around me don't understand mental health like I didn't understand. So I got to educate the people around me to even find out, you know what I'm saying, like what's going on and get used to medication and stuff like that and just.
So what happened at Signature that they discharged you?
Well, actually, Signature came up here and seen me, and they was she said
Came
she
to
did
the Cuyahoga jail or over here?
over here.
Okay.
I didn't
So-
call them or nothing. They
All
just
right,
came on their own.
But in May, they discharged you. Why did they discharge you? Were you not showing up?
I mean, sometimes I ain't show up some of the times, but I was still going. I still got, that's my primary care doctor. I still got a psychiatrist there I go see. I still do Zoom for a mental health lady, and then there's a caseworker there. So
Okay, hold on a minute. Dave, what does it say about, do you have anything from Signature as to why they discharged him?
So I spoke with Audra Kirschmeyer on August 15th. He had not attended any sessions since May 15th and only made it to 1 or 2 IOP sessions. Was also suspended from the Signature Health Transportation Program because he no-showed when rides came to get him. So they
Okay,
took
well, why was that, Ken?
well, in August they had put a warrant out for me, so I didn't see him none in August, and September I was in prison.
Cuyahoga put a warrant out for you?
Yeah, they put a warrant out for me, and
Okay,
that's because they said they sent me a notice to come to court, but I never got the notice.
all right,
I
so,
can't-
well, but you got also the positive cocaine test too, right?
correct, yeah.
Okay, so why were you doing, I mean, if you have, I'm trying to speak to you logically now, okay?
Right.
Were you on mental health meds through Signature?
Yes,
What?
Zoloft.
Which meds?
Zoloft, Trazodone, like 3 or 4 other meds that they gave me.
Okay, and that was, how long you been on those things?
Since April. I got out here like April, something like that.
Okay. So then why were you using the cocaine when you were on mental health meds?
I think it was maybe some, that I can't explain. Like I didn't, only thing I really used in my life was ecstasy, and ecstasy sometimes would come up as cocaine or.
Well, I don't think it does, okay? It comes up as something completely different.
Right.
Now, you don't know whatever you're taking, you don't have any idea what's in it.
Right, yeah.
Okay, but regardless of if you thought you were taking ecstasy, why were you taking ecstasy when you were taking mental health meds at the same time?
Well, I had stopped. I had stopped, but evidently, I still was, because I was thinking it was a Zoloft at first. That's why I put an appeal
Right.
in for Cobb
See,
County.
See,
But
what you
I
tell
take
me.
full accountability for my actions. I'm not trying to.
Right, okay, that's fine, except what you're telling me is that you at least have some insight to know that you have mental health issues you gotta deal with.
Right. And that's a learning
Yeah.
curve that I'm going through right now.
What's that?
That's definitely a learning curve. That's
Okay.
like very new to my whole life, my whole culture, everything. So trying to just get used to that and just trying to deal with it's a process. I'm trying to just
It's always a process.
right. I'm trying to progress
So,
without.
but once you realize that, and you determine, had you ever been, before this Signature Health time, had you ever been on mental health medication before?
Never. Nobody around me or nothing like that. Like I gotta educate the people around me and let them know like what's going on because I really don't know myself. Like
Okay.
that's why I was taking got them certificates down there because I still really don't know. And then
All right, so when you're taking these mental health meds, they're designed to bring a chemical balance to your brain. That's what
Correct.
they're designed to do. So if you're taking ecstasy or marijuana, okay, or anything else, then you might as well not take the mental health meds because it's going to screw up what that's meant to achieve. And then you're right back where you were because how old are you now?
I'm 47. I'll be 48 in March.
Okay, so
It's overwhelming sometimes. The whole depression thing is definitely new. It's definitely, I appreciate you for you the first time in 20, 30 years that a judge even said anything like, hey, maybe you got some issues, something like that. So,
okay, because this has been going on for a while because
Right.
you go back to 95
correct.
since the beginning of your adulthood with in and out of courts all the time,
Right,
okay? Mostly for drugs, a little bit of weapons.
right.
But
Nothing I'm proud of.
let me ask you this. You got, in Cuyahoga County, was it Pete Corrigan? Was he the judge?
Yes, Peter Corrigan.
Okay, so you land in that court on this non-support charge in 2018. And that, I mean, it was a disaster from the standpoint of you showing up or not showing up. And so you violate numerous times with him.
Correct.
And why did he send you to prison? You just had enough of the violations or what?
I was scheduled to get off in October. I didn't like, and then they came up with I think they was kind of upset. I think it was a mixture of everything. They was kind of upset that I challenged that they sent me a court thing, but they never sent me one. I said like,
Right.
so I went and got the UPS record. I went and got post office. They never sent me one, so they gave me another court date. As soon as he got me in the courtroom, he said, "Yeah, I'm keeping you," and then he just like he's not trying to help me or anything like that anymore.
Well, I know him a little bit, and I think the fact that he kept you on there so long with the violations.
I mean, because I was doing a lot of good things. It wasn't all bad. Like
How much you owe in support?
Well, it was 22,000, and now it's 9,000.
Okay. What do you do for work when you're not tangled up in this stuff?
I do films. I was in a few movies with Nicolas Cage, Willem Dafoe. I had some commercials with LeBron. I had like a lot of success. Like things just started falling apart. But yeah, I rent equipment.
What movie?
Oh, Dog Eat Dog.
When was that?
That was like 2019, 20, something like that.
Okay.
And then I do like commercials and stuff like that. Like
How do you get that work?
Angela Boheim, she's a casting agent and stuff like that, and she has various Hollywood plugs and local plugs and stuff like that. So I come in and do some camera work in the background if they need it. I do films, I do pictures, I do videos, things like that.
How did you pay down that support from 22 to 9?
Well, I had a shop until recently out there.
So how do you get paid on that? How do you generate income on that?
For videos like a singing video, rap video, commercials we charge $1,500. For me getting other people jobs, like sometimes I can't do it, so I get like an independent contractor. I get paid like maybe $1,100 to do it, and I get them like $300 to do it. You know what I'm saying? I keep the rest, pay rent.
Who lives there with you?
My mother, I take care of my mother. She has diabetes, lupus, and she has cancer. Then my sister has Down syndrome.
So who's taking care of them now?
Well, that's why I said I'm in good spirits that she just got out the hospital last week. So right now, this caretaker is coming through, and the whole family's pitching in and try to, fill the void that I put the situation in. So that's, that what I mean.
Let me ask you this. Do you acknowledge that you're Kenneth Hobbs?
Yes.
Okay, because remember back a couple of years ago when you first came here, you were telling me you wouldn't acknowledge you were Kenneth Hobbs, you were the corporate entity of Kenneth Hobbs. What was that all about?
Like I told you, I took some criminal law classes and certificates since I've been down this time, and I'm just like trying to learn the legal system because
Okay.
a lot of times I take accountability. I'm wrong, but a lot of times like I just be thrown in the system because my name been in the system. So, and I just be trying to just find out what's
because. So that was that sovereign citizen stuff, right?
I don't even know.
Freeman or stuff like that?
Right. I mean, I heard you say that. I Googled the stuff like that, but I never took it as that. I didn't know. I don't take no sides with sovereign. I don't have nothing to do with that. It was just me.
But you were kind of playing on the margins on that, weren't you? You were kind of trying.
Now that I know what it is, yeah, like that's what it came out to be. But I was doing it for us, just doing research and stuff like that. And the research was telling me like this is this is that. So that's what I was doing on the strength of that, like common law, maritime admiralty law.
It's all bullshit.
Right. You told me that last time, and so I haven't been doing it lately. You see, I've been sitting there and letting my lawyer talk and do things like that.
Now, because the reason all this happened, if you really sit in that seat you're in now and look backward, this all started on a traffic stop for like a red light or something, right?
Right.
Okay. And you were going to get a ticket or a warning, I'm not sure what it was, for a red light. You had a license, right?
Right, but I had a warrant for child support.
Okay,
That's why I was
okay. And this turned into a whole big mess
correct.
over nothing because you were being kind of a jerk at the traffic
That
stop.
I was.
Okay, so all this nonsense about this sovereign citizen crap did nothing for you except
Right.
cause you a lot of misery over the last 2 years.
Correct.
So if you sit in that seat and you think back and rewind the camera 2 years,
Oh yeah, I would have did a lot of things different.
silly ass shit, right?
Correct.
Okay. Now, so you're 47?
47.
Okay. So who's Savannah?
My girl's daughter.
Okay. So well, tell me your relationship with your girl's daughter, with Savannah.
She's she's just a little. I think she's like 9 or 10. She just likes to follow me around and like ask me little stuff. I do little camera stuff work. So she like just she's just a nice little girl. She loves my dog to death. So what I'm saying, I always bring my dog over. We play the dog. So I mean, she's just.
Where does she live?
They stay on Rockefeller.
Okay. All right, Mr. Watson, go ahead.
Thank you, Your Honor. May it please the court. I know the court is well aware of Mr. Hobbs' history. I know he has some problems, but he's here today, Your Honor, admitting to it. I mean, he's not sidestepped anything, I don't think. I mean, he's telling the court he's used drugs. He's had issues out of Cuyahoga County with the sport. He's trying to own up to everything. He's trying to get this cleared up. As he, in his own words, indicated, he wants to get all of this behind him so he can eventually get back, take care of his family, be with his girlfriend, be with his girlfriend's daughter. Your Honor, I do think there are some positives in his life. I don't know if the court will consider continuing him on community control for any reason. If it won't, Your Honor, he is currently still serving a sentence out of Cuyahoga County till December. I would respectfully ask the court to then consider a minimum sentence in this case, and if it would run it concurrent with the Cuyahoga case, Your Honor. Mr. Hobbs has not played any games this time. I think he's been very straightforward to the court, and I'm going to ask the court to take that into consideration, Your Honor.
All right, I'm going to keep you on community control, but I'm going to extend it by a few months. Well, for this time you've been in prison, so it'll terminate, if you make it that far, on 12/27/26.
Okay.
Okay, you're going to report once you get released. What's the expected release date?
December 6th.
Okay, so once you get released, you're going to report. First of all, when you get released, you're going to call Mr. Tompkins immediately.
Yeah.
And then when he tells you what date to report, you report.
Okay.
No drugs or alcohol with the
Right.
screens. You're to go back to Signature Health and get involved with their dual diagnosis problem for mental health and for drugs and alcohol. Follow those recommendations, complete whatever they tell you. Whatever medication you're prescribed, you're to take it only as it's prescribed.
Okay.
You're to maintain full employment. Is your license still valid or invalid now?
I thought it was still valid, but I don't know
Okay, if
if they
it's not,
suspended for Cuyahoga County or not.
if it's not valid, you need to get it valid. That's one of your conditions. And you're gonna pay the cost and supervision fee. So you appear to be completely different than you were back in, when I sentenced you.
Yeah.
You still got a lot of problems. but at least you're off the sovereign citizen crap.
Right. Thank you.
So, now I imagine that, maybe I won't say that. So you're at the point where if you're being truthful with me, okay, that you realize your way hasn't worked in the last 25 years, 30 years. And if that's correct, if that's your realization, then you're either going to make it work or the cycle continues, right?
Right.
Because now this is your second violation here, in addition with all the stuff going on in Cuyahoga. So you, I guess you got to figure out if you want to change what you're doing or you don't want to change what you're doing. Okay?
Thank you.
Anything else, Mr. Tompkins?
No, Your Honor.
Mr. Watson?
No, Your Honor.
All right, get it together, Mr. Hobbs.
Thank you.
Hey, everybody. Welcome again to American Courts. Today's Victoria's birthday, so everybody say hi to Victoria and tell her happy birthday again. I'm going to mention it every break that I can think of, Victoria. So happy birthday, and happy birthday. I'm not a singer, so somebody's going to have to sing it to her. Linus, I think you're up. Let's jump over to oh hell, let's go to Thurston County. They got a neat little small claims court thing going.
Get you started here in a second. I just need to bring up documents from your file. All right, so this is the plaintiff's claim against the defendant for $925.13 based on a security deposit. Okay. All right, the way we'll proceed here today is I'll swear the parties in, and then the plaintiff gets to go first and present your case first. And by that, I mean you can testify yourself. You can refer me to various exhibits and documents that are already in the court file. And you can also have people testify if you have witnesses that you want me to hear from. After I hear from the plaintiff, then it'll be the defendant's turn to do the same thing. Testify yourself, draw my attention to documents and exhibits that are already filed in the court file. And then you can also present any witnesses that you may have. During the time that we're doing this, I'm going to ask you to follow a couple of rules. One is please don't interrupt the other party when they're presenting their claim or their defense. Keep in mind that I'm very likely to hear different versions of things. The other party may say things to me that you don't think are true or correct, but keep in mind that you either will get your chance to tell me your version in a few minutes, or you've already told me your version, so I've already heard it. I expect to hear different facts, so you don't, I'm going to ask you not to interrupt the other party. I may need to ask you questions from time to time, and the reason I would do that is just to make sure that I understand your claim or your defense, and also I would do that to kind of keep things on track, to focus on the facts and circumstances that will help me to actually resolve the case. Some facts that you may want to talk about may not really be relevant to that process, so I might want to redirect you a little bit from time to time. So with that in mind, I'm going to ask you both, raise your right hand, please. And do you both swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
I do. All right, then I am going to hear from Kasianka first. Go right ahead.
Thank you. I'm requesting to have the remainder of my security deposit returned by the defendant. All of the items that were deducted from the security deposit would fall under where from normal use, according to RCW 59.18.260. This includes the charges for the carpet cleaning, filling pinholes, painting, and minor maintenance to old fixtures. And this home was built in 1895, and many of the fixtures in the home were on the older side. So, like light fixtures, like not quite fitting properly and things like that, and drawers not quite on the sliders. And so from that perspective, it's understandable from my perspective that fixtures, those kinds of fixtures need more regular maintenance than something that was new. And additionally, the largest expense that was notated on the security deposit disposition was not itemized, which is required by law. It was a lump sum for multiple items that were listed underneath that amount, but no specific itemized amounts were provided for those on the security deposit disposition. And I would also argue that even with that, those items that were listed under that section were also things that would fall under the legal description for normal use. I attempted to remedy the situation with the errors in the security deposit return with the defendant, and you can see in the file the letter that I sent to the defendant asking for the remainder of the security deposit to be returned with the reason why and the legal links to the legal information that was explaining why. I sent this to her twice via email and did not receive response and willingness to pay the remaining amount. I also want to point out that the defendant, I did hire a process server to serve the defendant, and I texted the defendant letting her know that there was going to be I know I probably shouldn't even have done this, but I texted her to let her know that there would be somebody who would be delivering her legal papers. And that process server showed up for 2 weeks straight trying to serve the defendant. And on 2 attempts, she was home, but did not come to the door. So we could not serve her, and we had to use other methodologies to serve her. And with all this evidence set forth, I believe that I'm at minimum entitled to the amount of funds that I have requested in this case from the defendant under Washington state law, and if not more, for the delay in payment. This totals at least $925.13, which includes the security deposit amount not returned within 30 days of move out, plus the charges that the defendant charged me for stop pay on the first check that she had sent to me with the incorrect legal name presented on the check, so I could not actually cash the check. And then also she charged me for the certified mail charges and the printing costs, so I would like to request for those to be returned as well. And I recognize that I might be entitled to more than just the $925.13, but that is all I'm asking for. And I feel like that's fairly generous considering what I'm entitled to. I do want to just add some clarification around the issue with the name on the check. And I don't think that this is even a necessary part of my argument. However, the check that was originally sent to me within 30 days of move out did not have my legal name presented on the check. And so I could not actually cash that check into my bank account. I was eventually provided a check that had my legal name on it because I asked for it, but I just wanted to note that.
Can I ask you just 1 or 2 quick questions? Can you tell me how long you lived at the house?
I lived there for about 1 year.
1 year? Okay. And can you give me the approximate dates when the tenancy began and when it ended?
It began early September of 2022 and ended early September early September of 2023.
So we're talking a 1 year period of time that you were there.
Yes.
Okay, understood. All right, and I am going to hear from Ms. Macy, but is there anything that you feel like you need me to know before I make a decision in the case? Because I won't you won't be addressing the court again on this.
I would like to encourage you to take a look at the pictures that were provided of the damages that the defendant was claiming. I don't know how well you can even see them, but I don't actually see what the damages are, and no pictures were actually provided of the carpet or the pinholes that were claimed to needing to be filled as a part of this security deposit disposition.
Yeah, I do have the pictures up here in the defendant's exhibits. Okay. All right then, thank you. Miss Macy, you can go ahead and present your side of it.
Thanks. I didn't provide a formal statement. I just thought that we could look at the exhibits and they would prove that this isn't normal wear and tear. Like Arlo said, she was just there for a year, and in a year to have the issues at the end of her tenancy that existed. We had over 60 push pin holes in the walls that we had to fill. We had damage to a brand new front door, and I did provide a receipt for that door to prove that it was brand new when she moved in. The remount of the bathroom ceiling light, the damaged cabinet base. If you look at exhibit, hold on, I'm trying to get to my exhibits. Exhibit C, when Arlo filled in the property checklist when she moved in, she did go into the kitchen and she did, I always allow my tenants to walk by themselves through the property for their inspection. I don't want to hover around them because I don't want to make them nervous. Arlo was very fastidious about opening every cupboard, opening every drawer, looking at everything, which is exactly what I want. I want them to note everything. And she did. She did a great job with the property checklist of marking everything that she found, including on Exhibit C, page 17, on the kitchen notes, noting staining under the sink. And I'd like to make sure the court realizes that that sink that she opened, admits to opening the drawers, cupboard drawers to view, is about 3 steps away from, if she just turned around, she would be at the drawer that was busted when she left the residency. And I did stand in that area and I did watch her go through that kitchen, and she opened every drawer, she opened every cupboard. Anything that she found would have been noted on this sheet, and there's no reason for a broken drawer to be left behind for me to deal with. As far as the light that had to be repaired upstairs, that was a brand new light. I had just hired a contractor to build that closet that the light resided in. That closet did not used to exist in that room. That was built for. We had done a complete remodel before Arlo moved in, a $16,000 remodel. That closet was built at that time, and that light was brand new. And you can actually see, if you look at the pictures that are included on Exhibit C, page 21, you can clearly see that the kitchen drawer is broken in that. You can clearly see the closet door broken from the track. And this wasn't just a matter of it being moved out of the track. That's something I could have fixed. The hardware was totally gone from this. And I also included the receipt for that. All my closet doors were brand new in the house when Arlo moved in. That same page, you can see the kitchen cabinet wall pushed in. That flooring was brand new, and I also included a receipt showing that the flooring was brand new, installed by a contractor. The contractor did not leave a gap there. It was clear that something had been pushed against it, like slid against the floor, because this is at the base of the cabinet where the sink resides. And it was clear that something had been slid across the floor and hit that with such force that it pushed that in. And I had to have the contractor replace that. You'll see mention on that same page of the GFI in the bathroom being tampered with. You can tell it's tampered with. You can see that somebody has been in there with a screwdriver removing it and they did not get it placed back correctly. When I walked into that house for my inspection after Arlo moved out, that bathroom light that you see broken from its base was flickering, and the closet ceiling light was hanging by its wires. Both of those were hooked up to this GFI thing. So we could tell, contractor could tell that the bathroom had been tampered with, the GFI had been tampered with, and we ended up changing out that bathroom light. I did not charge her for that. The light fixture hanging from the closet ceiling, you can tell that that's a brand new fixture by the blue plastic that it is housed in. That is not an 1895 base. And again, this was all work done by the contractor. The work that was done before she moved in was all done by my contractor. You can see on the next page of Exhibit C, you can see the damage to the metal front door. That was a brand new door. You can see my receipt there for it. It looked like she had tried to nail something into my metal door. And then you can also see some scratches about 6 inches underneath that nail hole where something had been hung there and you could see that like the wind or something had shifted it and it had scratched the door. So we had to fill that and repaint. Again, I've lived in my house for 30 years and none of these things have ever happened in my house. These are not normal wear and tear. I expect when a tenant leaves, I expect it to be left broom clean. Arlo certainly did that. It was broom clean. But that doesn't change the fact that these problems are not normal wear and tear, and it should not have been left in this way. I'd also like to direct your attention to Exhibit T, page 59. The lease. I belong to a Rental Housing Association of Washington, and I belong to them for a reason. I want all of my leases, all of my forms to be as current as possible and up to date with the RCWs. And it clearly states that if there is a maintenance issue, it needs to be reported. And it also clearly states that the house needs brought back to the condition it was in before the tenant took occupancy. You can see on here on page 59, there are several pages here of emails from back and forth between Arlo and I talking about the only maintenance issue that she ever reported while she was in there. And you can see if you read that text that I did my best to mitigate what was happening as quickly as possible, including going out and buying something an evening before I was scheduled to leave town and delivering it to her back door so that she would have it before I left town. And then you can see that I checked in with her afterwards to make sure it was okay. If these items, as Arlo had stated when we mediated the first time, Arlo had stated that all of these problems existed before she moved in. And if that were true, they should have been reported at the same time that this issue was reported, because we were certainly taking care of things at this time, and that would have been a great time to take care of it. I'd also like to respond to what Arlo said about the server and me being home twice when she was here. I wasn't actually, I mean, that's kind of true. The first time the server came to my door, she posed as a DoorDash person delivering food, which I hadn't ordered, so I had no reason to answer the door. And I did talk to him.
The service of process isn't really important to me deciding this case.
Okay, great. I just thought that I needed to counter what she had said. You can see before photos. They are presented. Hold on, let me see. I've got my table of contents here. I do have before photos that are, let's see, it's Exhibit G, shows before photos of all those areas. The only thing, Arlo mentioned the pinholes. The only thing I didn't get a picture of is the pinholes, and that's just because I can't get pictures of the pinholes. They're too small. They wouldn't come out. Everything else I have pictures of. You can see on Exhibit G, page 30, The photo of bedroom 1 with the new closet doors that I've already shown a receipt for. You can see the bathroom that had the GFI that was tampered with and the light tampered with. You can see the bedroom closet. Like I said, that was a brand new bedroom closet. We had just created it. There used to not be a walk-in closet in this bedroom. That used to be hall space. I took away from the hall, changed where the entry door was. In fact, you can see where the original entry door was because you can see that I've added a light switch to the bedroom. You can see one on the wall and you can see one out in the hall wall. That's because bedroom to accommodate taking up the hall with that closet. You can see in photo 4, the kitchen drawer looking just fine. And again, inspected by the tenant before she moved in. Unfortunately, Exhibit G with the kitchen cabinet doesn't show very well because it's dark under that cabinet, but you can see that's new flooring. I just put that flooring in. My contractor that installed it would not make a mistake of having a gap between the cabinet base and the thing. And you can see photo 6, the front door, the metal damage hanging. I don't know how important it is. I didn't realize I could have witnesses here, or I would have had my daughter come here today because my daughter has been with me on every project. She's my right-hand man, my huge assistant. She knows what this place looked like before Arlo took over, and she knows what it looked like after Arlo left. My daughter has been with me every step of the way, and she did include a statement. If you look at, hold on, I'm trying to find it. Marissa Lee, my daughter, she's Exhibit S. And if you look at Exhibit S, you'll see my daughter making a formal statement confirming that the before pictures are accurate, that the after pictures are accurate, and I don't know what else I need to prove. Sorry, I've never done this before.
I think you're starting to repeat yourself now a little bit. So, no, I'm familiar, or I think I've got a good grasp of what your defense is, and I've seen the exhibits that support the statements that you're making, and you've also walked me through some of them, which also helps me understand your defense. So yeah, this case is fairly common sort of situation that we see in small claims court with a landlord-tenant disagreement about the disposition of a deposit. A lot of times these disagreements boil down to exactly what Arlo said in the beginning, which is this normal wear and tear, or is this something in excess of normal wear and tear? So in many cases, it's difficult to distinguish what is normal wear and tear versus what exceeds that. There's no universal standard to that, and the subjective standard of one person could be significantly different than the subjective standard of another person. But in your case, both of you have presented some pretty good evidence, some pretty easy to follow evidence, and some pretty good photographs that help to see and illustrate the points that you're making about whether we're talking about wear and tear here, or whether we're talking about damage that exceeds wear and tear. So I appreciate you both taking care to do that, because it actually makes it a lot more clear for me to be able to come to a decision here. And what I am going to decide is this. I'm going to decide based on the evidence submitted, the testimony, and the exhibits, that the damage that we see here in the exhibits presented by both parties is in excess of normal wear and tear. And you've got to show by a preponderance of the evidence that your claim, the claim that you're entitled to the return of the full deposit, and you haven't carried that burden, because it has been clearly shown that in a period of 1 year, which not a very long time, that a house that had been very recently brought up to a higher standard had some damage to it that really only can be explained by being used in excess of ordinary wear and tear. And that's quite obvious. I mean, that GFI cover plate is pulled off, and there's clearly been an attempt to put it back the way it belongs, but it's not. It's clearly misplaced. It's very odd that a light fixture would be dangling by a wire, including the box. The mounting box is on top of it. So, you know, it's clearly been pulled down from its mounting position, which is not ordinary wear and tear. And neither is a drawer cover broken completely off. It's in excess of normal wear and tear. Don't know how it happened, but it's not normal wear and tear. So unfortunately, I am not going to make any award here. I'm going to find in favor of the defendant. And there'll be no award of any damages.
Thank you, Judge.
All right. I will write up a judgment that's consistent with that, and you can both have access to that judgment later today when the clerk files it.
Appreciate it.
All right, we're going to go on to the Lauren one. I know some of y'all was asking what Lauren's part in all this is. She's just waiting for her turn in front of the judge. So I believe hers is the next one. Let's see where it goes.
All right, thank you.
Can you hear me now?
Here, that's much better. Okay. So this will be number 37373, and I understand that the plaintiff, Ms. ML, you were contemplating asking the court for a continuance of this trial.
Okay, when I went into the mediation, an office manager appeared, the gal Karen, and I said to the mediator, she's not part of the case. And she said, okay, she could be a witness. I had said to her when I filed the case, I got told at the clerk's office that you have to ask the judge for witnesses or production of documents. One of the things I need for you to see is the doctor took befores and after of the procedure, before the procedure and after the procedure. And I asked for her office staff a year ago and the doctor to send me those photos, either by email or whatever. All they sent me was an email that I gave the court, but I really need for you to see those before and afters 2 weeks after the procedure. And I need to either dismiss this case, start a whole new case, and have witnesses because of the scar damage in my face and what happened. I didn't know I was allowed to bring another provider here or,
Well, in a medical malpractice case, you're practically required to.
The thing is, the standard of care wasn't provided by the doctor. And
so can I hold?
Yeah.
Have you stop for a second? Are you asking for a continuance so that you can gather more evidence that you need to present to the court as part of your claim?
Can the court order her to can I make a production of documents for that?
No, you're in the wrong kind of court for that.
Okay.
The rules that govern what you're talking about there, discovery rules is what that's called.
Okay.
That kind of court rule doesn't apply in small claims court. Small claims court is a lot more informal, and there aren't procedures like that in place for discovery.
Okay.
The parties just kind of, they do it themselves and they present it themselves. It's designed for more or less straightforward legal disputes between people that don't require a lot of effort to develop the case. If you're interested in using discovery tools like making the other side produce things like documents or answer your questions or things like that, those are civil discovery rules that apply in district court or in superior court. And you are free to dismiss this case and file it in district court or superior court according to your judgment.
And you know what? I think that's what I'll do, Your Honor, because the standard of care wasn't provided. The medical records I wasn't able to get from her in her office, and the photos, and they're impertinent for this case.
All right, I will go ahead then.
So I will file a district court and have her reserved and do that. I think I'll, that's what I'm going to do.
Okay, then I will enter an order dismissing the claim without prejudice.
And what is the, for the, I can still file district court here?
You can.
right? Okay.
Yes, it just wouldn't be a small claim.
Right,
There aren't any discovery.
okay.
Uh,
And I'll do my discovery then.
procedures.
I think I'd rather do that.
Okay, and if you're gonna pursue a medical claim like that, it's probably a good idea to get some legal advice about it so that,
Well,
you know,
my ex-husband was an attorney for 30 years.
All right. Well, I will leave it to you to decide. So, so Omnicenter and Dr. Preiser, the matter is dismissed.
Thank you.
Thank you, Your Honor.
You're welcome.
All right. So Lauren's whole part was she was the wrong person to be in court. And so she had to sit through all that other craziness with the landlord stuff. I'd never be a landlord. I've been a tenant a few times, and I don't know that I've ever had a hard time moving out or a hard time dealing with the landlord. But at the end, there's always money questions. There's always curiosity about it because I always pay my security deposit and I always feel I take care of the apartment. And of course, there's plenty of reasons to, I couldn't imagine the security deposit covering all the costs that are involved in moving out. So I don't argue with them. I'm happy to be moving. I just move on about my way. We're going to jump over to, let's jump over to another O'Donnell. That was a good one there. Let's see. Oh, I'm gonna go to Judge Fleischer, one that Kim had mentioned yesterday. I was gonna save it for Allie's show, but Allie's out and about having fun, so we're gonna go ahead and jump to that one. So here we go with Judge Fleischer. It's one that Kim was asking for yesterday.
Could put a sock in between. They could put a piece of paper in between.
We're pushing a bond. The defendant's not here today, though.
2 days.
Why?
He's been in jail 2 days, not here.
What's the name?
Would you go ahead and say it now?
Yes, so his name is Luis White.
White. Hey, Stephen, any reason why we didn't get White?
Right now, earlier he was showing still in processing, so I'm looking him up at the moment as we speak.
Even as we speak. So I was talking to Ms. Tang, and she indicated to me that basically you would not set a bond until he's present. And so his family is here, so I'm telling them so that they won't think I'm lying and that I didn't come
The
here.
family.
There's something, you want to come on up?
And Judge, just so you know, I think my supervisor Katie is on Zoom today. I'm not sure if she's in the room.
Oh, yeah, she is. Okay.
And yes, Your Honor, he's still actually in processing.
How so long?
Because it could be that they claim medical, they can claim, so that actually prolongs it even further.
So I assume, based on what Ms. Tang said, it's not unreasonable that we have to wait until Monday before we can have you evaluate.
What's up, guys? Hello.
Hi.
Thank you for coming, guys. I don't know anything about, is it your son?
My brother.
Your brother? And
My father.
your father? Okay,
So my
guys,
nephew's son.
I don't know anything about Mr. White. All I know is that he's wanted out of a different state for some charge. I don't even know what the charge is. Typically, what we do, if we set a bond on someone, we need their body here so we can explain to them what happens if you don't go, the ramifications, because it's different when you hear it from a defense lawyer versus when you hear it from a judge.
Okay.
So that's why we usually wait until we get a body here. Now, as Stephen said earlier, typically someone gets processed within 24 hours unless there's some other issue that is raised. Could be medical, could be mental, and we just don't know. Do you, Stephen, you don't know as to why at all?
It doesn't tell me in here, but also it does look like he had multiple aliases in the system, and it was a spin.
Consolidation? Okay, so that could be one of the issues there, that they're trying to reconcile who the actual person is, and it could take a little bit longer. You know, when someone has a bunch of aliases, they have to look at who it is, go through all the criminal history, go through pen packs, meaning fingerprints, and all that takes time. What's he wanted for?
It's a failure to appear from Dane County, Wisconsin for a burglary room within a building, 2 counts, contributing to delinquency of a child, 2 counts, robbery, theft, and false imprisonment. There were 3 warrants issued from 2000 to 2001. It was set for a final conference in November of 2000. failed to appear to that. They issued another one in
The
December
cases are from 2001.
2001. Yes.
He was
Wow.
18.
No, he was 16 and he turned 17 in their custody.
Have you talked about doing a lawyer out there, about?
Yeah, they hired
No,
me.
I mean,
I
it's
was
been-
hoping that we would be in a position where we could get a bond set and then have him go up there and resolve it, because I am confident they're not gonna wanna go forward on it.
Does he have any criminal history in between that time or just that?
I'm not personally able to look that up. Maybe Katie could speak to that.
Katie, do you see anything?
Let me pull him up, Judge. I was running his history now.
Katie, are you gonna be nice today or mean?
I'm always mean, Mr. Monk.
Thank you.
Regardless, I can't do it until I
So
get his
we'll be
body.
back on Monday.
Yeah.
Right?
And then we can certainly talk then for sure.
Yes, sir.
But,
The only thing that I could add to this, my brother is taking care of his family. Without my brother, my sister-in-law has no way of providing for herself. Her children have no way of providing for themselves. The oldest one is 21. The youngest one is 2. He's got SPTAN1, the 2-year-old. There's only a limited amount of cases. There's only 9 other people who's got this in the world. And what it is, it's seizures, and also there's no exact time on how long this child may live.
So here's what the judge is saying. He's not gonna be able to set a bond until Louis is here.
it's that important. I mean, he's known since 2000 that these things have been pending.
At one point, he tried to take care of it, but then
Trying is never good enough. It's like, unless you're playing
It's
what,
not
horseshoes or hand grenades, right?
maybe an adult, but he's more in a childlike mind.
Yeah, we'll
He's
be
not
back on
very
Monday.
smart.
Get it, but understand that I have to make him aware of a lot of things. And if I don't tell him and I just give him a bond and he takes off, well, I didn't know. This person never told me,
I'm standing responsible for
No,
him.
ma'am.
but I can't put you in jail if it doesn't happen. Not that I want to.
I'll be back on
We'll be
Monday.
back on Monday and we'll be more than happy.
I understand that you're concerned and I appreciate your concern and I appreciate you coming. I'm not saying no to a bond, but I need his body here. And
This is my little brother.
I understand. It's not the end. We're going to come back in just a couple days and we'll take care of it. Okay?
Thank you, Your Honor. I'm sorry if I spoke.
No,
up.
no, no. I'm happy that you came. Okay? Really.
Thank you for
coming.
your
Of course.
time.
Meet you outside. I'll meet you outside.
Mike, and just tell them it's every person. It's not just them. Every person that comes here. I understand. Totally. Yeah, for sure. Hopefully we get on Monday. Hi, Ricardo. Come on up. Happy Friday.
Happy Friday. I'm approaching on Ramon Barahona. You asked that he come today instead of his regular court setting because he's got a BVR.
Come up, Mr. Barahona.
Sorry, Judge, I would like to say that the BVR is kind of, it conflicts with itself. It says there's a tamper, then it says there's alcohol detected, but alcohol cannot be confirmed because of the way it was tampered with. So I don't know if we have further information to.
We never do. We never do. And the problem is that what happens is people try to put stuff. What is the one thing I asked you? I'm sorry, I ordered you not to do?
Not to drink alcohol, and I haven't. I'm 51 days sober today. And
I
I
have-
live in a sober living facility, so I get breathalyzed and drug tested at least 3 to 4 times a week. Anytime that I leave and I come back. I went to an inpatient program and I completed that. I have my certificate right here.
Show me that you have a breath test on 10/26 at 9 in the morning, because if what you're telling me is true, you should have a breath test at around that time, and let's see.
Yeah, I would have to get with the coordinators of the staff at the place that I live in. I'm sure they have it all logged.
You're supposed to have that here today, though. Today's the day that's set for your bond violation hearing.
Well, Judge, we didn't go over all that because I was hoping to get more detailed info. It sounds like there's a tamper, but they're not confirming alcohol. They're not confirming alcohol.
Because of the tamper. What we have normally is someone does something to the device to the integrity of the device to bypass alcohol detection. They could put a sock in between, they could put a piece of paper in between, they could kind of move it so the skin is not touching the device. There could be a whole myriad of things of how the actual tamper takes place. All we know is that we have a tamper and we have a we have alcohol detected. We can't confirm because of the tamper. The nature of the tamper prevents confirmation of alcohol.
Judge, sometimes these devices, they're not perfect, Judge. They can't ever tell me what happened.
So if there's ever a problem with the device, it is your responsibility to go to the place and get it fixed.
Yes, sir, and I did. Whenever I went to Sentinel, I asked the guy who put it on me and was downloading my data, I asked him to tighten it because I felt as if it was too loose. And he did tighten it, and he said he wrote down on his notes that he tightened it for me. I've been sober for 51 days, and
how do I know that?
I have my certificate that I went to an inpatient program, and I'm living currently in a sober facility. And I'm doing that for myself because I do have an alcohol problem, and I'm 51 days sober as of today.
If you're telling me that you have all that information, that they test you frequently, then you should be able to have testing at that time. And if you can show me that you have a breath test at that time that shows that you're not have alcohol on board, then I'll throw the piece of paper away.
Can we do this, Judge? Would you allow us to get time to get those documents for you? We weren't prepared to present that to you today. I was looking to get more info on the actual report.
It's supposed to happen today. You guys are supposed to come in between the time we let you know about the violation, to do your diligence, to figure out what the violation is, how it occurred, and how to remedy that.
Judge, that diligence isn't on us, Judge. They're the ones alleging this. They need to provide.
They're not alleging anything. I am, because you have alleged violations here. It is your duty to show us why
We could bring these people that are alleging this tamper, we could bring them and have them testify regarding what they know and what they do not know. Instead of just assuming that they are correct, we could have a hearing.
No one's assuming anything. I'm telling you, if you have something that contradicts this, show it. That's what I'm telling you.
I also did my due diligence of making them tighten it. I told them to tighten it myself.
I understand.
And he did say he wrote a note about that. Because I was still like this would happen.
Mr. Barahona, I still have alcohol detected, regardless of whether it's tightened or not. The tightening is not the issue. The issue is that there's a tamper and that we have alcohol detected.
I have not consumed any alcohol.
So show me. I'm telling you how to do it. Reach out to them now, see what you can get. See what evidence is out there to show me, I'll put you guys to the side, reach out to them, see what they have. If you're telling me that they've tested you as frequently as they are, they should have something.
Let me talk to my client, see how quickly we could get that info.
No rush. No rush. Take your time, see what you can find.
Okay, thank you, Judge.
Okay. Anna.
Judge, we're approaching on Mr. Ramon Barahona.
Do you need until Monday?
No, because here's what's going on. So I was kind of unsure about what he was talking about. And after talking to him, we're not going to have a breath result for him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you could revoke them. You could say, well, let me talk about what the specific is on the revocation. Alcohol was detected during tamper. However, alcohol.
Hold on a second. Was that Linus that just walked by? I didn't recognize that earlier. Let's go back.
For him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you you could revoke them, you could say, well, let me talk about what the specific is on the revocation.
I didn't remember this from earlier. I didn't remember seeing Linus walk past. So, hey, everybody, look at Linus.
Alcohol was detected during tamper. However, alcohol cannot be confirmed as consumption because of nature of tamper. So I would argue, I'm not conceding that something happened. I'm conceding there might be a tamper. I'm not.
Come up, Mr.
conceding
Barahona.
consumption. If you're going to revoke him, I would ask for a full-blown hearing. If this is one of those situations where he's just admonished and, hey, this is your one shot, then he understands that. I don't know how you want to proceed with this, Judge. I'm not conceding that he drank alcohol. He's been in this location, in this center core location since September 17th. He did inpatient. October 18th, he graduated. Then he moved over to Center Core Sober Living Facility on October 18th. He's been in there since then. We have proof of that. He's been attending 6 meetings per week, 1 counseling session per week, 1 group counseling session per week, 3 AA meetings. He's there. He's doing something. I would ask that we just admonish them.
Machines don't test positive for shites and giggles, man. They don't. There has to be something there to make it test positive.
Well, Judge, on that aspect.
It doesn't spontaneously test positive for alcohol. For you to say that it does, it's just disingenuous and not true. There has to be something to set the machine off. It doesn't spontaneously test positive.
I have not consumed alcohol for 51 days as of today.
The machine is telling me differently, Mr. Barahona. You know how many people tell me the same thing with the exact same facts that you have? You know how many times I hear it a day?
I would assume a lot.
If I had 1 strand of hair every time I heard it, oof, I would look good.
Judge, I did talk to him. This wouldn't be much of a solution since this is from 1026, but we could test him today. I don't know how long something stays in the system, if that's the allegation, but he's willing to test today.
That's going to be no
Right.
bearing on me. I
Right.
mean, this is 2 weeks ago, you know?
I get it.
I'm just now, unfortunately, they just give us the results now, but
And regarding the actual, I've gotten reports before that says what this device is reading. There are reports out there that they can provide.
if they don't tamper, then yes, you will get a true and accurate reading. And that's what the problem is that there is something that was tampered with, and Mr. Barahona knows. He's the only one that knows what happened on that date. We don't, because we weren't there. We don't know what happened. So I'm sorry, Mr. Barahona, but I told you one thing. I told you one thing only, you know?
I would like to state the fact one more time that I did tell the people at Sentinel to tighten it because I didn't want something like this to happen. I don't
This
think
is
it's
not a matter of tightening. It's a matter of alcohol detection. If a device is loose, it's not going to test positive for alcohol. You understand that?
I
Just,
understand what you're-
there has to be an intervening event that has alcohol in it for it to test positive. And there's something seriously afoot because the device is telling us that someone is messing with the machine. If we not had the messing with the machine, then we would know whether there was true alcohol consumption or not. But here we have a positive and that you're messing with the machine. Okay, goes with you.
Well, so what'd y'all think of that? He ended up getting to go to jail. So, if any of y'all know what happened later, I couldn't find anything that happened to him later. So maybe he'll show up on Monday or something. I'm not sure. We're going to show another Judge O'Donnell one. I see Kathy was still in the chat, so I'm going to do another one for her. Kathy does a lot of Judge O'Donnell on her channel. I'm not sure you'll find it anywhere else. I'm a big fan of Kathy's and court vibes, and so she got me watching Judge O'Donnell. And sometimes I see one that I keep waiting to see on hers, and she's so busy, she's got so much going on. Every once in a while, I can grab one. So we're gonna do Judge O'Donnell, and then I think we may see what else we got here.
This is 23-367 and 23-970, James Walsh, violation of community control. Violation, positive urine screen, September 9 for cocaine. You understand that charge?
Yes, sir.
Second charge, positive urine screen for cocaine, September 16th. You understand that charge?
Yes, sir.
Ms. Novotny?
Your Honor, we're just asking for any leniency with regard to sentencing today. Previously, my client did admit to the violations in front of you. We were working in our office with our social worker, Aaron Mayer, and ultimately were able to receive a letter from Landmark Recovery regarding a bed that would be available for our client. They pre-accepted him upon the court's granting of him to be released to Landmark Recovery. So I do have a letter documented, and I know we mentioned it in chambers with that respect. My client is a union pipe fitter. He's been a union pipe fitter since 2010. He also works on automobiles on the side for Bob's Auto. He's very concerned, Your Honor, if there is a prison term involved here, that he would lose his house.
Well, he's not that concerned because he keeps doing cocaine.
Your Honor, he's informed me today that he believes in 8 days that he will potentially lose his house since he has not been working. He will lose everything, and that's what his worry is.
Well, whose fault is that? I mean,
Your Honor.
How many times you got to come here with the same stuff?
Your Honor.
And then tell me your concern is your work in your house.
Your Honor, sir.
What?
Can I elaborate?
We haven't started yet, so there's nothing to elaborate on. So go ahead.
I'm just being kind of slow. I'm really nervous to address you today.
Why? You're very experienced at it. You keep coming here, so you don't have a problem. So you're used to it. So go ahead. Don't be nervous.
It's hard to control, sir. I am nervous. Since 1987, I took care of myself and worked hard. And, you know, Mrs. Savotny here has presented this to me. It's another month upon availability. I haven't worked in 5 weeks. There will be no place to go.
Whose fault is that?
When I stood up, sir, I took accountability for that. And
No, you didn't. You don't take account. You don't. What do you mean you take accountability for?
Well, how should I convey this to you? I'm not sure how to word it. I've been in jail almost 5 weeks. I learned my lesson, my heart, mind, body, and soul. And I need another chance. I deserve it. I'm a good, hardworking citizen.
What do you mean you deserve it?
Sorry, sir?
How do you conclude you deserve it?
Well, because like I was starting to say to you, is that I'm a good, hardworking citizen. On the first year of probation, I went off the road twice. Excuse me. Like I said a minute ago, I hate to be redundant, repetitive. I learned my lesson so bad. I had a lot of time to think about my actions and what I do. And I thought about my career and that, and I need a place to live. I don't have anybody. I'm by myself. My wife passed away some years back. I just need another chance.
Why do you keep doing drugs?
I don't want to say stupidity, and I don't want to say addiction either, because I was in here one time with you, and I said I'm not addicted to anything except cigarettes. I think I even got that beat now. I just timing and people, places, and things.
Did they tell you to use that phrase over here? Or what?
No, sir. Nobody told me to do anything. I'm talking to Judge O'Donnell.
So, Nicole, what did he tell you with regard to this cocaine use?
Well, essentially, he kept saying, no way, and then he said he was around people who used drugs, and then he kept saying, no way, and at that point I said, let's sit here in silence and wait for the deputies
Okay.
This is the third time we've done this.
I remember speaking with her, I'm just overwhelmed, just overwhelmed. Everything flashed in front of you, it's like, man, I drove a car, I'm not going back to work. Sometimes you're just out of timing of what to say.
Okay.
I wasn't trying to disrespect my probation
Well,
officer.
it's not a matter of respect or disrespect. I mean, you can't tell the truth.
Yes, I can.
Well, you don't. I know you probably can, but you don't.
Sir?
You've never told the truth since you've come in here. Okay? Now, if you're not addicted to drugs, then you've made a decision that you just want to keep doing it, regardless of the consequences.
I don't want to keep doing it.
Well, then why do you keep doing it?
Like I said a few minutes ago, Your Honor, I was on probation 6 or 8 months. I went off track twice. I effed up.
I know.
I
know
effed
that.
up.
I know that.
Okay.
I know that because this is the same speech you give me every time you're here.
I'm not giving you a speech. I'm just
Okay. So I know you effed up. Okay. Otherwise, you wouldn't be here.
Right. And
but that's not the topic of discussion. The topic of discussion is if you're not addicted to drugs, why do you keep doing drugs? Now, the honest answer is you are addicted to drugs. That's why you keep doing drugs. Because you're addicted to drugs, we give you treatment options that you blow off, okay? Because you don't want to do it.
That's not true.
Okay, tell me what's true.
What's true is something, and listen, and I know I'm wrong, sir. I'm begging, I know I'm not here, you're not putting me to death or anything. I'm begging to keep my life above boards where I'm not homeless. I'm pleading with the court for some intensive outpatient, I just so I can work.
Didn't you create the problem?
Oh, yes, sir, I admitted that twice, yes. There's no question about that.
Okay.
Yes, sir.
So what I'm supposed to do is ignore all the crap you've pulled since you've been on probation because you won't have a job when you're done. Is that what I'm supposed to do?
I don't want
I mean,
you-
don't you keep using the same goddamn excuse every time you're here? The answer is yes, you do.
I saw you one time before, sir. I'm human, I'm 54 years old. I just want to be able to take care of myself. I did almost 5 weeks in jail. I'm being repetitive. I learned my lesson, sir.
If you want to take care of yourself, then why don't you take care of yourself?
I am.
No, you're not.
Oh, okay.
Otherwise, you wouldn't be standing here in the blue uniform.
You're 100% right.
Well, I am 100% right, but it doesn't take like a genius to figure out I'm 100% right?
Yes, sir.
I mean, it's no great revelation, right?
Yes, sir.
Okay. You just, first of all, from the get-go here, you have insisted that you don't have a drug problem, yet you keep testing positive for drugs. So you do, whether you just won't admit it. Okay. So you're on probation. We give you the availability of treatment, and all you do is blow it off and keep using drugs.
Sir?
Yes?
I'm not blowing off any treatment. I'm not.
Then why are you here?
I'm not really sure that I understand. I'm not blowing this opportunity off for treatment. I just, what's going to happen is a bed's not even available yet. Okay, so
That facility is a piece of crap, okay? So that's not even an option.
wow. Okay, I didn't see that. I didn't expect that you could say that. But
in the end, it doesn't really matter whether it's a great facility or a lousy facility, okay? You're not interested in it, okay?
I'm not.
And you've proven to me you're not interested in it because you keep doing drugs, even though, as you say, you're not addicted to them.
I'm not against any services, sir. I'm not at all. But I would just like to continue to work and keep my home. I have nobody to turn to for help except James.
If you wanted to work and keep your home, then why do you keep doing drugs?
You're 100% right.
I know I'm 100% right. I know that. Okay, you don't have to point that out. Okay, if you don't want to use drugs because you want to keep your job in your house, then you ought not to use drugs so you can keep your job in your house. It's simple.
I learned my lesson, Your
Especially
Honor.
since you're not addicted, right?
I learned my lesson, Your Honor.
No, you haven't learned your lesson. If you learned your lesson, okay, this same discussion we had last time would have prevented you from coming here this time, had you learned your lesson. The bottom line is you really don't give a shit about any of this. You want to do what you want to do.
That's not true.
Okay? It is true. You've demonstrated it's true. It's objectively true.
Give me another chance, Your Honor.
Anything else you want to say?
I don't believe what I needed to. Please, Your Honor, have mercy on me.
Why don't you have mercy? You don't.
I love myself.
Otherwise, you wouldn't be here. All right, on 23-367, I'm going to terminate your community control because you're no longer amenable after I reviewed this pre-sentence report and gone back over the entire record. So you're going to serve 6 months in prison with credit for 76 days. The costs are assessed on 9/70. 6 months in prison, credit 55 days, costs, and these sentences will be concurrent to one another. Anything else, Ms. Novotny?
No, Your Honor.
All right, that was it on that one. I like how he very clear, very direct, very plain. We're going to jump to an older Judge Allen video. I really like Judge Allen, and watching his court over the last few weeks, there's just not a lot going on there. He's very direct, and he did a good long one today, or I watched it today, so I'm assuming it wasn't on live today. But it's a long one, so it would be an hour and a half to 2 hours just for that one hearing, and I haven't ventured off into that yet. So, but this is a good one from Judge Allen, and then we're going to play the Judge Webster and Jared Regier matchup later on. And there's some folks that haven't seen that one. We played it live earlier in the week, but we'll play it again on the way out. So here we're going to look at Judge Allen.
Okay. Is there somebody named Daniel that's supposed to be a part of these proceedings?
No, it's Devontae Smith. I'm using my son's phone. I probably should change the name.
Okay. So your case is not for another few minutes, Mr. Smith, okay?
Yes, sir.
Yes. All right, so we're going to put you back in the waiting room. So, Ms. Brown, then this is your motion. If you'd like to be heard, go right ahead.
Yes, sir. I filed my motion because I was late to the hearing due to a medical condition. And you want me to go into detail of what happened?
Whatever you think you need to say, you go ahead and say.
I had a seizure before the hearing, and I still tried to make the hearing because the advice of the attorneys, I can't think of the legal aid, said to make sure that I don't miss the hearing. And so I called to let them know that I was still, I was coming and on the way. I did make it near the end when Miss Holzman.
This probably is Miss Kingsley.
Okay. And so they said they were, no, it was Miss Tosman and Alex Tosman. And
I don't know who Alex Tosman is. I know that Miss Kingsley usually represents Palace Law Firm, but maybe there's somebody else that I'm not familiar with.
Yes, Ms. Tolzman, Alex Tolzman was representing him that day. And so I came in at the end, and the proceedings were still going on with some of the other residents as well from Meridian, as well as other hearings for Best Tech. And you advised me to contact Mrs. Tolzman, as I did. I've contacted her as soon as leaving the courtroom. I called her a couple of times. I even found their email, sent them a couple of emails, called a couple more times, still no response. I even called the courts to see, has there been a change? Had you signed the document? Nothing had been done. I still reached out to them again, not until after you signed the eviction that I then received a phone call from the plaintiff.
So when you filed to have this motion to set aside heard, there was a form that you wrote on?
Yes.
So that form has some of the requirements that you have to be able to meet if you want to try and have an order entered. Yeah, that form in front of you.
I do. Yes.
Let's see what Ms. Dornbush wants to say. Ms. Dornbush.
Thank you, Your Honor. Just to confirm on the day in question, I would acknowledge that Ms. Alex Tolzman did appear for court on our behalf that day. You are correct that normally Ms. Kingsley is the individual that appears for our firm. Ms. Tolzman was there that day. After Ms. Brown contacted our office, and I actually am the individual that spoke with Ms. Brown and let her know judgment had been requested and submitted to the court for entry. I did reach out to Ms. Tolzman. Ms. Tolzman indicated that she did not have any record of contact from Ms. Brown. Nonetheless, Your Honor, with respect to the motion at hand, I would object to setting aside of the default judgment as Ms. Brown has failed to file an affidavit of fact setting forth a meritorious defense to the underlying action, which is in fact required under the court rules. I would also point out, Your Honor, the total due at present is $14,554.33.
Okay. Ms. Brown.
Actually, I did attached my statement along with documentation to show the emails that I sent to their office requesting Mrs. Tolzman or someone from their office to contact me, as well as documentation from my doctor's office that also indicates that I had the seizure that day, as well as the following day in my doctor's office as well. And she is correct. Nothing has been paid because her client has not made the necessary repairs as stated, which I also reached out to the Meridian Township inspectors, who also told them that this stuff needs to be done, have 14 days to do it, and still that stuff is still not done. And they have also removed my email address from the website where I'm supposed to request for maintenance to come in for maintenance issues.
Your Honor, if I may.
Sure, go ahead.
Your Honor, with respect to her claims that repairs have not been made, that is untrue. My client addressed these repairs in December. As far as the township inspector, there was one issue that the township inspector advised needed to be addressed. That was a tree removal, and that's been done. There's nothing else that the township told my client needed to be repaired.
let me stop you because I don't want to get into what is arguably a side issue. We don't get to any of those issues about repair unless the default is set aside. Right now, there is no case because there is a default. So the only thing that exists is the judgment that was entered as a consequence of there not being payment. So Ms. Brown, I don't want you to get the issues confused and start arguing about whether repairs were or were not made, because unless I rule that that default is set aside, there's nothing for you to be engaged with. So the big hurdle here is, and I referenced this to you when I said that you have a form, because the form is based on what the court requires, what the court rules require, and the court rules require that you show good cause and a meritorious defense. You said that you sent in an affidavit telling us that you had a seizure and that prevented you from being present. Okay. Let's assume for the sake of this discussion that I say that that's good cause. I'm not saying that that's what I'm doing, but let's just assume for purposes of the discussion that I'm going to say that that's good cause. There's still the necessity of being able to show a meritorious defense. And I don't hear anything being argued about a meritorious defense.
I guess I'm confused. I don't understand, because I was told that because of the medical condition and what happened, I didn't.
So understand what I just said. The court rules require you show both things, and I'm willing to give you some grace with regard to whether you show good cause because of the fact that you had a medical emergency. But there's still that second prong that has to be proved, and that is a meritorious defense. Having a seizure is not a meritorious defense, even though it might seem like it could be. Under the rules, it is not a meritorious defense.
So what exactly then is I'm sorry,
A meritorious defense, if you look at the piece of paper that you signed, it actually says meritorious defense, and you can actually just kind of Google that, because I would be hesitant to tell you that because then you may not still have an understanding, and I don't want to confuse you. You have your phone with you, you can click on Google, or if you
on the form it says I have a meritorious, and then it has quotation, which I thought in the meaning is valid, a valid defense.
Yeah, you can read it and say, you can read that as being a valid defense.
Oh, okay.
You can do that. So what is your valid defense?
Well, I thought the valid defense was that I had the seizure, which prevented me from.
Remember, I just explained to you that that's not what that is. What you could use that seizure for is to show that you had good cause. That was the reason that you didn't show up.
Sorry.
That's in the court. That's certainly not me. I wouldn't have a window screen.
Please the meeting now. Recording in progress.
This judge is being way too patient with her. I guess it's a situation where he's just going to let her paint herself into a corner.
Let's see. So it's the notorious offense is the legal term that refers to defendant's stated reason why the plaintiff or prosecutor has no valid case. It is a defense that addresses the substance or essentials of a case rather than dilatory or technical objections. A meritorious.
I don't need you to read that to me. I understand what that means.
Okay. I guess I don't understand it because I'm not an attorney.
You are today, you're representing yourself. I can't represent you. If I represent you, you should win. I'm the one that's supposed to decide based on the arguments in front of me, what I listened to from you and from Ms. Dornbush. What should happen?
So it's basically saying that, I'm sorry.
And as I said before, I'm willing to give you the benefit of the doubt and say, okay, I'll find that there's a good cause because you had a seizure. I'm not even asking for proof of the seizure or anything like that. I'm willing to give you that allowance. So you don't have to prove that.
So it's saying that the plaintiff have no case.
As I just said a moment ago, I'm just listening to the arguments and making a decision. Well, I'm going to have to go on to the next case. I have another case that I have to hear. I wanted you to have an opportunity to tell me or to make the arguments that you needed to make in order to grant what it is that you want me to do. And at this juncture, I'm going to have to say that you were not able to do that. Okay. So your motion to set aside the default is going to be denied.
You need me to prepare an order, Your Honor?
No, actually, she submitted the order, so I'll just sign the order. We'll
Thank
get it
you,
out
Your
in the
Honor.
mail to you folks, okay? We'll get it out in the mail to you guys, okay?
Thank you, Judge.
All right, I'm going to throw on the Judge Webster and Jared Regier issue from earlier in the week. We had played it earlier in the week, but Debbie and a few other people hadn't seen it, and it's about time for me to get out of here. So I'm going to go ahead and throw it on. You guys have a great night. I really appreciate y'all coming out, and I appreciate this experience you guys are sharing with me. So let's do it again tomorrow night, and hopefully tomorrow night we're going to have Allie and Linus on. We're going to do our best for it. So you guys have a great Saturday night, and here's the Judge Webster and Jared Regier saga.
This is Dallas Curvin Sawyer. Please announce appearances.
Peter Hagan from the state, Your Honor.
Peter Hagan for Dallas Sawyer, who appears with me.
And how does your client wish to proceed, Mr. Hagan, on this one count of voting under the influence?
Well, Your Honor, this case has been going on for about a year.
Yes.
We still have yet to get the blood results. And we've been asking for those, and you ordered them probably the last 2 times we've been in court. And I still don't have them. My office calls, they said they've provided all the reports. And so here we are. I mean, I should make an oral motion, to dismiss this case based upon the time that this case has been going and the lack of blood results.
Mr. Regier, your response, and I know this probably isn't your case, but you're on the spot with it today.
Yes, Your Honor. This is a case where it is the state's understanding that blood draw reports and KBI lab reports were were involved in this matter. I have communicated with my colleagues. It is the state's understanding that counsel for the defense's office communicated with my office back in March, and that at around that same time, both the blood draw results and the KBI lab reports were provided pursuant to standard discovery procedures, and all discovery has been provided in this case.
Well, even if that is the case, why in the world, since March, could you not have given him another set? I mean, that to me just seems like a obvious solution to this. If whether he has them, whether you sent him or not, he's saying, I don't have them, I need them.
I received all the reports, Your Honor, and there weren't any blood tests in what I received. And we've been asking for this, and they said they'd provide them.
Right. And I know people are human, and it may have accidentally been left out and not, someone didn't realize it.
And Your Honor, I did
communicate. There, and Mr. Hagan's staff misplaced it. I don't know, but he needs those reports. He's been asking them since, oh, I don't know, April, June, again on August, now in November. Why can we not just give him another copy, Mr. Regier, if you know the answer to that?
Your Honor, I did communicate with my colleagues regarding that this morning, and it is the state's understanding that an additional and that my office did make those available again this morning. So
all they need to do is send me the lab.
That's all they need to do. And I've told you to do that. I've told your office. And I suspect, Mr. Regier, that you've put notes in your file telling people to do that. And I just don't understand why it's still an issue. Well, Mr. Regier, is this Mr. Sweeney's case? Is it Mr. Canfield's now, or is it yours?
Your Honor, it would appear that unamended information was filed in this case. My name does appear to be on it. If counsel for the defense will communicate with me directly, perhaps that will enable a timely resolution to be reached in this matter.
Okay, so they put you on the case. Had you filed the amended information, or I shouldn't say they had you. You filed the amended information January 30th of 2024. And it does have your name on it. And I understand that in this business, the prosecutor doesn't personally put the paper in an envelope and mail it or fax it or whatever, but unfortunately the attorney is the one where the buck stops. So your staff is telling you they sent it in March. You don't have any indication that they tried to send another one after I ordered them to several times?
One moment, Your Honor. Your Honor, in reviewing my notes, it would appear that I did request my staff to review this back on August 19th, and it was confirmed that the reports were provided. I also have a note in my file which would appear to indicate that the reports were successfully received by counsel for the defense's office on March 12th of this year at approximately 10:26 a.m.
And how do your notes confirm that?
In communications with my staff, Your Honor, as well as a certain ledger concerning the issue of discovery.
All right, but you don't have anything confirming from Mr. Hagan's end that he received those? Just that
Your Honor, it would appear that there is a note in my file which would appear to indicate that an email was the issue of discovery to counsel for the defense's office on March 12, and it was confirmed by the individual from counsel for the defense's office that the email was received.
Mr. Hagan, do you have a response to that?
Sure, Your Honor. What I received March 12th were all the reports that I know of from them, and they did not have a blood test with them. Every time we've been back to court, I've said that. And my office called and said, send the reports. They said, we've already sent them all, just like he's telling me again. And so here we are, how many months later, and all I've asked for is the lab results, and I don't have them to this date. And every time we've been to court, that's all we talked about. He said he would send them that day last time. And the time before. So I'm confused.
I am too. I know both attorneys are officers of the court, and you're both very credible, responsible attorneys. And so I'm in a very difficult position, not knowing what to think, because I know that Mr. Regier is very diligent. I know that you are as well, Mr. Hagan. My suspicion, if I had to just come up with without saying someone's just not being truthful, which I don't think that's the situation at all.
No, I don't think that he's anything other than we've asked for him and I haven't got him.
That's the troubling part. And that's saying, well, we sent them back in March is not satisfactory to this court. Every time I tell you to send them, I expect them to be sent. And not this, well, we've already sent them, we're not going to do it again. That is totally unacceptable. This is the defendant's right to this information. It is the defendant's entitlement to see the evidence against him, to question it, to examine it. And he is being denied the right, whether his attorney lost the documents, whether the county attorney's office in good faith thought they included them in that email, but left them out. They've been told multiple times, get them there. So it's been about 210 days-ish, approximately, since first appearance in this case. And counsel, why should I not just dismiss it right now? Because I have told the county attorney's office multiple hearings now over the course of months to send him those blood reports. If he's got them, so be it. Send them again. Do you have a good answer on that, Mr. Regier? And I know you're in a tough spot here, but the buck's...
Your Honor, if that is the court's order, and if the court is prepared to take a brief recess in this matter, I can communicate with my staff regarding this issue immediately.
Would you do that, please? I know
Certainly.
we've got a lot of hearings to cover today, but I know this is a big issue. 0.15 while voting, that's a big issue. So if you would, Mr. Regier, I'll certainly give you time to come up with that.
Thank you, Your Honor. And if the court is prepared to go into a recess, it looks like Mr. Patterson is back on this docket. So I'm not sure what the court wants to do as far as that is concerned.
Well, do we have another prosecutor?
I believe Mr. Canfield is on the Zoom.
Okay, I didn't see Mr. Canfield. Yeah, you take your time to figure that out. So, because I want to try to get this figured out today, so we don't just keep coming back for another year.
Very good, Your Honor.
Thank you. All parties appearing as before. I believe I posed at least a rhetorical question to you, Mr. Regier, as to why I shouldn't dismiss this case based on its history and certain facts. And Mr. Regier, have you a response at this time?
Your Honor, again, the state's understanding is that discovery was previously provided in this case. I have had communicated with my office further regarding this matter, and it is the state's understanding that the requested information has been provided to counsel for the defense, and counsel for the defense has confirmed receipt of the same.
Okay. Mr. Hagan, you didn't ask to have it dismissed. You brought up that you could or might or should, but what's your position?
Well, my position, Your Honor, is he tells me that they sent this in April. In June 17th at court, he ordered them to provide me the reports. June 17th of this year. Then we were back on August 19th. I still didn't have it. They said they would provide it. They still haven't provided it. And I don't know how he's trying to stand on what he sent me in April or whatever, because, you know, we've been to court several times. He's been ordered to do it. They said they would do it that day. And now he's trying to say, well, we already sent it, so that doesn't count. Under the statute, Your Honor, he has 180 days, and we're past the 180 days. And I don't see any excuse for him not to have provided it to me by now. So I'm requesting that the case be dismissed, Your Honor.
Mr. Regier, do you have that document in front of you?
I do, Your Honor.
Would it not have just taken a couple of seconds for the county attorney's office to fax or email that again to Mr. Hagan?
Your Honor, unfortunately, I would need the opportunity to discuss that issue with my colleagues further.
I think it's a common sense answer. You know, I could say that, yes, the county attorney sent it in March or April, and that Mr. Hagan just lost it. The worst possible scenario, Mr. Hagan is, you know, I hate to even say or suggest that the remote possibility that he's just using that as a stalling technique. But you can't even do that when I keep telling the ordering that the report be sent every 2 months. If you were telling me, yeah, we sent it every 2 months, every time you ordered it, Judge, then Mr. Hagan would kind of start looking suspicious that he either wasn't running a very efficient practice or that he was in the habit of losing things or worser issues. But now this defendant is entitled to a speedy trial. And I don't see that he's been given the speedy trial. And because I have ordered multiple times that that the alcohol and drug evaluation be turned over to the defendant, and it has only been allegedly turned over once back before I ordered it.
And Your Honor,
Mr. Regier?
It is also the state's understanding that the request information has been provided to counsel via email, and I believe Your Honor may have been included on that same email as of this
Saying
morning.
An email of what date?
This morning at approximately 9:37 a.m., Your Honor.
Well, Mr. Hagan, have you seen a 9? Well, that's
Your Honor,
after this hearing started.
I've been on Zoom. I've been on Zoom since 9 o'clock this morning.
So
If he
have
said
I.
it this morning, I may have well received it, but I haven't looked for that, Your Honor. That seems to be quite late to.
Yeah, I'm not going to take the time to look at that. We've already used far more time on this case than what it should have taken. I'm very, very troubled at the thought of just summarily dismissing this without hearing the evidence. But I also have to recognize the defendant's right to a speedy trial. I'm going to hold this in abeyance before I make a decision on it. I want to do a little bit of pondering and reviewing speedy trial and so forth. Jen, do we have any time on a 1:30 before? Well, Mr. Hagan, are you available on 1:30 Wednesdays?
Which Wednesday?
Well, I don't know which Wednesday. I just want to make sure you didn't have something that kept you tied up every Wednesday.
No, I don't have it every Wednesday afternoon.
Okay. Jen, let's see if Jen can squeeze this in for
yeah, that's
review,
actually
so
a
I
good
can-
day for me. So
How soon are you wanting it, Judge?
Oh, what do you have, about 2 weeks maybe? Would that be workable?
I've got a good opening on the 20th of this month.
that's fine.
How about November 20th at 1:30, Mr. Regier?
No objection to that date at this time, Your Honor.
All right, so I will meet with you all again, client, Mr. Sawyer as well. On that date and time, November 20th at 1:30 to render a decision on what to do about this. In the meantime, Mr. Aguirre, what the heck? I'm gonna order it again, send him the report and see if there's any chance that you could talk your staff into getting it to him.
I will put it on the file, Your Honor.
All right, and I'm just talking about the alcohol and drug evaluation, that's all. He seems to have everything else. All right,
Very good, Your Honor.
thank you.
Thank you, Your Honor.
We'll be in recess.